Well, as I've spoken to my learned friend, Mr. Speck, he says he doesn't know how long he needs. He hasn't heard from us yet on the bits he's entitled to reply on the basis that we're going to be about 20 minutes on the bits he's entitled to reply on. I hope that 50 minutes will be enough for him, and we'll try and sit down at 20 to 3.
Well, he's happy with that.
Well, I'm not sure he is. I don't think he knows, because he...
First time I've heard that. I don't want to be difficult.
Yeah, well,
it's very difficult to say how long you're going to be in reply to something you've yet...
We can probably accommodate 10 minutes, I think, but if you really need it, yeah.
I'm grateful. So, my Lord, I'm turning to my learned friend's appeal on claims 10 to 12, and we submit that what he put to you yesterday amounted to a full frontal attack on the evidential findings of the judge, which far exceeded the respondent's approach in the Court of Appeal. And one needs to be very careful about the way in which the evidence was characterised. So can I take you to the statement of facts at Core Bundle 1, MS 112, and just show you the facts as they are agreed. And particularly, please, would you remind yourselves of paragraphs 25 to 27.
'85 to '87.
25 to 27 on page MS 112. So we have secondary hyperalgesia and allodynia present in a large majority of patients with neuropathic pain, that's 25. Central sensitization contributed to peripheral neuropathic pain, 26, and was involved, at least as an amplifying mechanism, in both inflammatory pain and peripheral neuropathic pain in 26. 27, central sensitization was not thought to have a role in central neuropathic pain. Can you just write next to that, also see paragraph 193 of the judgment? Because the evidence was that nobody knew. It wasn't that it was thought not to have a role, it was that nobody knew whether it had a role, and we say there is a distinction there. And then in paragraph 28, A, just towards the bottom of the page, you'll see the recording from paragraph 211 of the judgment. Central sensitization plays a role in the second phase of the Rapport formalin test. And then in paragraph 29A, you'll see that the Bennett model was a well-recognized model of neuropathic pain, and that reflected the evidence from Professor Wood and recorded in the trial judgment at paragraph 74. And in addition to those passages, I'd also ask you to have in mind the two comments at the judgment, paragraph 207 and 208. It's MS 785.
Sorry, what was the paragraph?
207 and 208.
Yeah.
MS 785, 207, the judge records that it was common general knowledge that the second phase of the RAP formalin POR test had a central sensitization component. And last sentence of 208, the judge recorded that the formalin test was not purely a test of inflammatory pain. Professor Wood accepted this. So, my Lord, we say, based on those findings, the standard, that being standard, is it plausible, is it reasonably credible, an educated guess, was easily reached. And moreover, the Court of Appeal in paragraph 46, or where the reader is encouraged to try the invention in the patent, the evidence was that the skilled person was encouraged to try, as both Professor Wood and
Are you submitting that the fact that you think something's worth trying is good enough to satisfy the test?
My Lord, yes. I mean, that's actually a higher standard than that's the, as my learned friend put it, that's the worth trying with a reasonable expectation of success. That's the obvious standard, and in fact, the threshold is lower.
It's the reasonable expectation of success that's the critical part of that formula.
Yes, but that's it. Both the experts, and this is the evidence I'm about to show you that the Court of Appeal accepted, said they were interested in this and would want to do it and could do it. And they would go straight ahead and put it into the Bennett test. And that's the link that my learned friend said was missing. If you apply the Salk test, we say it shouldn't be applied, it's just an example, but even if you were to apply the Salk test and say needs to be a direct effect of the drug on the mechanism, that is satisfied by carrying out the Bennett test. And
All that the specification says about the Bennett test is that it exists.
yes, but the expert gave evidence, and the judge and the Court of Appeal accepted that the skilled person would go and carry it out, and it would work. That's
Work isn't material.
well. If it didn't work, then they'd stop, and you.
But it isn't material unless it's disclosed.
No, my lord. I'm sorry. This is where we part company. The case law is quite clear that you are entitled to use your knowledge from the common general knowledge, from the patent, to put into effect what's disclosed to you in the patent. So it's
You're
what you
entitled
take.
to use common general knowledge in order to understand and interpret the patent.
And act on it.
What?
And act on it. So
Yes.
it's not what the patent
But there's got to be
discloses.
something in the patent which common general knowledge helps you to understand or interpret.
Yes, and that's what the findings were. The skilled person would recognise that central sensitisation was being assessed in these examples in the patent. It was common general knowledge that central sensitisation formed part of peripheral neuropathic pain, and the expert said they would want to go ahead, even if they didn't think it was plausible based on the document itself. They would go ahead and do the test that's referred to in the document, and it was a common general knowledge test as well, and that is sufficient to make it plausible. And that's absolutely consistent with the approach in the European Patent Office and every other decision on sufficiency. You are entitled to carry out routine trials in order to put the patent into effect. And based on the patent and the common general knowledge, the evidence was that the skilled person would do that here.
But you are entitled to carry out routine trials in order to put something that's in the specification into effect. I mean, there's nothing in the specification about central sensitization. It's emerged as the keystone of the arch.
Yes, but that's because it was part of the common general knowledge. That was why we succeeded with the peripheral neuropathic pain, because the judge found that central sensitization was part of the common general knowledge, and I showed you the evidence from Dr. Scadding where he accepted that.
What do you say is new? What is the contribution that the specification makes to the knowledge? What's it add?
That pregabalin would be effective to treat neuropathic pain.
That's it.
That's it, and it gives you some data to support that.
Well, what data are you referring to?
The rat-poor formalin test, which shows central sensitization is reduced by the giving of pregabalin, and the skilled person would think that that was sufficient to make it effective to treat neuropathic pain. And if they didn't think it was sufficient just by reading the document, then with their common general knowledge, they would put the pregabalin into the Bennett test, and they would provide the further data as a matter of routine trial. And that, as the Court of Appeal accepted, is sufficient to support the claims.
Did the rat formalin test show specifically that central sensitization was reduced rather than inflammatory pain was reduced? Or simply pain was reduced?
It showed that pain was reduced, and the finding was that the rat-poor formalin test was not purely a test of inflammatory pain. That's the finding I've just shown you. And if the skilled person would understand that it was reducing central sensitization, and therefore if it was doing that for inflammatory pain, it was also reasonable for the patentee to suggest that it would be effective for neuropathic pain, even though there wasn't data from a neuropathic pain test actually recorded in the patent. But that doesn't matter, as I've shown you in all the EPO authorities.
Processes for the relief of inflammatory pain don't work for neuropathic pain.
Well, you have to be a little bit careful about that, my lord, and there are two separate findings. There was a finding of the judge about NSAIDs, and one of the points there was that, in fact, the concentration of the NSAID is much lower than it needed to be in the tests that were done. So you're right that you can't take aspirin to treat neuropathic pain, but that doesn't mean that the skilled person wouldn't think it was credible that this drug, which had been shown, as I showed you in opening, shown to act very differently from morphine, it was a novel and interesting effect, as the experts explained, that this wouldn't be a useful drug to treat neuropathic pain because it treated inflammatory pain in the tests, and the central sensitization component was common both to neuropathic pain and inflammatory pain. And that's the basis of the findings of the judge and the Court of Appeal. And can I show you?
Do we actually know that in relation to inflammatory pain, it worked? It had an effect on the central sensitization, on that element of the pain?
Well, the evidence was that the experts thought the data was convincing in the patent. In
and
relation.
then you extrapolate from that so that if you have a neuropathic pain which won't necessarily have a central sensitization element, will it?
It won't necessarily, but most did. It was
But
generally.
most did. And you
Yes.
say that's good enough? That,
Yes.
If it addresses what most, is that the test substantial?
Well, is it the plausible, reasonably credible, educated guess? And of course, not every patient needs to be treated successfully.
You have to have two stages. Firstly, it doesn't have to cover absolutely every situation. That's the
Yes.
cancer case.
Yes.
And then secondly, it's plausible enough that it covers a substantial number of them.
Yes.
The neuropathic.
And we say the evidence from the experts was absolutely clear on that, and the evidence I showed you. And can I just show you one part of the judgment, Court of Appeal, you haven't been asked to look at on this? It's it's the section where the Court of Appeal deal with my learned friend's appeal, 129 to 134.
MS?
MS 575 to 576. And particularly, so paragraph 132 is where Lord Justice Floyd assesses the rat-poor formalin test in the way I've set out. And then paragraph 133 is where he expressly deals with the section of evidence I showed you the other day, where the experts agreed they would want to go and carry out the test.
I'm not sure I understand. Forgive me if I'm, or it's helpful if you'd explain if I'm not following it. But in 132, we're told that the patent demonstrated that pregabalin was likely to be effective in the treatment of inflammatory pain.
Yes.
The skilled reader would recognise inflammatory pain had a central sensitization component
Yes.
as an amplifying mechanism. The skilled reader would also know that PNP had a central sensitization component as well. Now, what I'm wondering is, would the skilled reader know that pregabalin was affecting the central sensitization component?
Only because if you recall, it was only effective in the second phase of the rat-poor formalin test and not the first phase. And that distinguished it from drugs which just...
It's only effective?
Only effective in the second phase. So if you were going to anaesthetize the animal, then you'd have a drug that affected both the first phase and the second phase. But because it affected only the second phase, the evidence was that the skilled person would understand that that was characteristic of central sensitization as compared to anesthetizing.
Is that spelt out anywhere in the judgments? I've been trying to find any kind of explanation of what is meant by central sensitization plays a role in the second phase. But you, I think, if you're right, advanced my learning significantly. I'd like to see where it
Yes, I will get Mr. Copeland will find that while I continue. So, my lords, paragraph 133 we say is significant because this links in with paragraph 46 of the Court of Appeal, where they say if the reader is encouraged to try, that's good enough. Here in 133, they accept that the evidence that they would try was justified.
Just go back to 132 for a moment. It said that the test results would not have enabled a firm prediction of efficacy for PNP to be made. Why would that be the case if the test results implied that central sensitization was reduced?
Well, my lord, I think, again, trying to summarise the evidence was just because it was successful in this test, you didn't know it was necessarily going to be successful to treat inflammatory pain or neuropathic pain. It was an indication that it might well work which is all that was required. But of course, things go wrong at every stage in scientific research. And this is the point that's made in the Salk case that my learned friend took you to yesterday. You can't know that an in vitro test is definitely going to predict efficacy in a patient. All you're trying to do is get them somewhere on the way, and as Salk says in paragraph 10, so as to not put an undue burden on the skilled person to make it work.
But the judge's analysis was much more specific than that. I mean, he first concludes that the rat test was predictive of the efficacy of a drug for inflammatory pain, and then after a long passage over several pages looking at the rival evidence and all the cross-examination, comes to the opposite conclusion for neuropathic pain. He's not just saying, well, it might do in both cases. He's saying it does in one and it doesn't in the other.
Well, it wasn't predictive, and it was never suggested. The judge says, I characterise Warner-Lambert's argument. They didn't put it this way, but I characterised that they were suggesting it was predictive. We never suggested it was the rat-poor formalin test was predictive of neuropathic pain, but that's not necessary. That's not a necessary standard to be met to satisfy the plausibility test. It just has to be reasonably credible, an educated guess. And the experts were at one by the time we got to the end of the trial that it did make it credible. And you've seen the evidence to support that and the judge's findings.
You said you had some, or you were going to come back later with some passages which make good your submission a moment ago, that the reason why a skilled person would think that pregabalin worked on central sensitization was because it only had an effect at the second phase of the rat-poor test.
Yes, let me, again, I'm going to put that on my learned friend Mr. Copeland's list, if I
Okay.
can, and I'll give you those at the end. My Lords, so the other mistake, which we say respectfully my learned friend made yesterday when addressing his appeal, was his attempt to elevate Salk to a rule of law, and that attempt has been roundly rejected by the courts below, both in this case and in other cases, and rightly so. And it's also been roundly rejected by the EPO, and again we refer you to the dasatinib case, paragraph 3.9, where they say...
What's that? Oh, that's the
CML case.
CML. It seems to have about 4 names, yes.
Yes, I'm sorry.
Bristol-Myers
Bristol-Myers is the official name, where they say, paragraph 3.9, that Salk is limited to its facts. Now, all the relevant parts from Salk are in the Court of Appeal judgment, which is why I didn't go to it directly in opening. But if you do look at it, and I'm not sure that I've got time to do it now, we urge you to read the whole of the Salk decision, and not only those parts which my learned friend took you to yesterday. In particular, so it's paragraphs 5 to 13, and they make clear in that decision, the TBA make clear that there was no evidence at all in the patent to support the claims. They hadn't even identified the molecule, let alone show that the molecule they were trying to claim would have the effect, the medical effect that they suggested. They characterize the approach as being one of undue burden in paragraphs 10 and 12. They say, so this is again consistent with our submission that it's all about enablement. And they conclude that the invention that was purported to be claimed in Salk was actually only made several years later and required a research program. So we say this is a very extreme case. It's just one example. And the specific requirements set out in the passages which my learned friend took you to should be confined to the facts of that case. It cannot be a one-size-fits-all approach. And indeed, if there was a requirement to show a direct effect of a drug on a mechanism, and that effect reflects the therapeutic application in every case, then you could never get a patent in an area where you had a disease where the mechanism was not fully understood. However good your hunch, Lord Sumption gave the example of anaesthetics earlier in the case, and we say that if you were to apply the Salk approach rigorously, then it would shut off whole areas of research where patent protection would not be available simply because the mechanisms weren't fully understood. My Lords,
anaesthetics, you could establish the hypothesis by tests, but you don't have to explain why it works, is the point I was making. but that's not the only way of establishing that it's plausible that it does.
Well, my learned friend's approach seems to be you have to explain why it works. And
No, I
this
don't
the
think
link
he is
between
saying that.
the
Because,
mechanism.
I mean, he's, as I understand it, accepting that tests which went to the particular therapeutic effect that one's talking about would be relevant.
But there are other ways of doing it. You don't have to do it that way.
No,
That's
quite.
my point. We say that, therefore, just because you don't fall within the precise wording of the example that's given in Salk doesn't mean you can't satisfy the test. My Lords, the Court of Appeal dealt with Salk, paragraphs 40, 46 to 47. We say it's a compelling analysis. They applied it to the facts of this case at 129 to 134. We say, even if contrary to our primary argument, that you needed to show a direct effect of the drug on the mechanism, that's done by applying the drug in the Bennett test as the evidence I should take you to in 133 of the Court of Appeal. So even if the Salk standard is a requirement, we met that standard in this case. Indeed, the judge rather bizarrely commented in paragraph 344 of his judgment that the questions I'd put to the witnesses on sufficiency were put on the basis of an obviousness test, not a sufficiency test. And I respectfully agree, we have actually gone as far as showing it was obvious to the skilled reader of the patent that it would work when they carried out those tests, and so we say we meet the test on any basis. As to that, finally, we say the suggestion that the test should be the same as obviousness would be a radical departure from the existing case law. The courts have repeatedly found that that isn't the right approach. It would affect both first medical use claims and second medical use claims, and for the reasons we set out in our case at paragraphs 106 to 113, we say there is ample authority for you to reject that, including the authority of the House of Lords, the Connor case, the Supreme Court in the Lillian HGS case, and of course the Technical Boards of Appeal in both AstraZeneca and the Bristol-Myers CML case. And we do commend the reasoning of Henry Carr J, albeit at first instance, but it is the very well thought out and reasoned as to why the obviousness test is not the right one, and that's Authorities 1, tab 2, paragraphs 172 to 177. Finally, my Lords, we don't accept the thought experiment that my learned friend put to you, in the sense that you could get multiple patents in this field if we're right about the standard. If the patent is plausible in the sense of enabling, as we submit, then a plausible patent will be novelty destroying for any later patent because it discloses and enables.
Yeah, the first will win.
The
first will win in
yes,
this situation.
Yes.
It won't be a question of two competing valid patents.
Indeed. So the obviousness would never come into it. You don't need to get into obviousness. If it discloses it and enables it, as we say is the standard, then it will destroy novelty. That's Synthon in the House of Lords. And of course, my learned friend has no example of this ever having happened, even though this plausibility standard has been applied in the EPO for some years. And he hasn't been able to come up with an example of this ever being attempted. Finally, my Lords, construction. It was our primary case at trial and on appeal, to the extent it matters. You'll recall the evidence is that no one on this side of the court understood the point until a week before trial. So all the expert evidence, and indeed our opening skeleton, was silent on the point. Of course, had we or our experts said anything contrary to the construction that we advanced and have continued to advance since it became an issue, then no doubt you'd have heard about it. We didn't, and it's not just luck that we didn't say anything to the contrary, because the case throughout was that the claims were limited to neuropathic pain caused by central sensitization, which is what the skilled reader would understand, and that, of course, is consistent with the peripheral neuropathic pain construction that we advance. And it wasn't just this side of the court that was silent on it. Professor Wood was silent on it in all of his 5 reports. He didn't ever draw a distinction between peripheral and central pain. And the judge directed on day 1 of the trial that we shouldn't put the same point to both witnesses to avoid duplication. So Professor Wood didn't give evidence on it. and B, I was directed only to put the case to one witness. So I put the case to Dr. Scadding, who was the second witness in the case after Professor Wood, and there was no attempt by my learned friends to re-examine Dr. Scadding on that point. So, my lords, that was the trial. As far as the approach to construction of patents is concerned, we say the easiest starting point is the recent decision of this court, Activists and Lilly, Authorities Bundle 1, Tab 1, paragraph 58 of that, Lord Neuberger at MS 1309, refers to the judgment of Lord Hodge in Wood and Capita, and he clearly had Article 69 firmly in mind, because that's what he was dealing with, and we say there is no inconsistency between a standard approach to construction of patents and contracts and Article 69. My lords, you were taken to Glaverbell, a fairly old case by now, Authorities 2, Tab 23, but that did establish that expert evidence was admissible on technical terms and that the court should avoid a construction which results in an unreasonable result. What my learned friend didn't do was go to any of the modern patent authorities that we cited in our case at paragraphs 160 and 161 at MS 188, where the courts below, Court of Appeal and First Instance, have sought to avoid a ridiculous or foolish result, to avoid prior art cited in the specification, or to maintain the sufficiency of the patent. Nor did my learned friend attempt to address the EPO approach, the synthetical approach that I told you about in opening, and we say that it's significant that they had no answer to these. So, my lord, how would the skilled person approach this patent? They'd approach it based on their common general knowledge. The finding below was that there was no set definition for neuropathic pain as a matter of common general knowledge. There was mixed use, and that's the Court of Appeal, paragraphs 110 and 111. So you have to look at the specification of the patent to obtain your definition, because there was no single definition that otherwise applied. And we submit that the skilled person would see immediately in paragraph 6 the definition set out. They would have every reason to think it was meant to be a definition, because they would know from their common general knowledge that there was some dispute and some variation in the art as to how the term was used. It's not complex for the skilled person to work out what it means and how it applies. Dr. Scadding was quite clear. He answered in 4 questions what he thought the patent was confined to in this respect.
You thought that sentence was definitional, didn't he?
He did. He did. And we say he had good reason to.
If that's admissible. If that's
admissible. But it is it's a technical term, and the court is entitled to know what the skilled person would have made of it. Had there been a single definition in the common general knowledge, then the court would have taken account of that in construing the patent. But there wasn't, and that's the evidence at 110 and 111, and therefore the judge was entitled and should have looked at the evidence of Dr. Scadding in coming to his conclusion. And my lord, contrary to my learned friend's submissions, that sentence in paragraph 6 is not the only support in the patent, because all of the other information about neuropathic pain types is consistent with that definition. You were taken to Dr. Scadding's table at MS 1029 yesterday. Not all of the definitions in the patent are in Dr. Scadding's table, but the ones that are there are all peripheral. And so all of the other neuropathic pains in paragraph 3 are peripheral neuropathic pains, and none of the conditions in paragraph 6 are exclusively central. Now, the patent allocates phantom limb pain to idiopathic pain, and we challenged the finding of the judge on appeal as to whether this was neuropathic pain or idiopathic pain, and the Court of Appeal preferred the classification of the patent. And you can see that in paragraph 94 of the Court of Appeal's findings, and therefore they went on in a paragraph 114 when dealing with construction to proceed on the basis that phantom limb pain was idiopathic pain and not neuropathic pain, and they also, as my learned friend accepted, held that fibromyalgia was not neuropathic pain either, contrary to the findings of the judge. The only other element in paragraph 6 which has been referred to are the vitamin deficiencies, and it's been suggested that is a mixed condition, but that wasn't relied on at all at trial. It was only raised for the first time in the Court of Appeal, and we, in any event, we say that can be explained away because there are vitamin deficiencies which are peripheral neuropathic pain, and therefore it's all entirely consistent. So the points made on construction were about the breadth of Claim 1 or the other conditions in paragraph 3, and our response to that is that the list of other conditions in paragraph 3 is primarily relevant to the definition of pain in Claim 1 and cannot be relevant to the attempt to define neuropathic pain to the extent that they are not neuropathic pain types. Further, we say the breadth of Claim 1 assists us, not my learned friend, because given its breadth, the skilled reader might well think that subsidiary claims were intended to be narrow because everything else is scooped up by the breadth of Claim 1. My Lord Mance asked why would the patentee want to exclude central pain conditions, and one very good reason was that the skilled reader would understand that central sensitization was a unifying characteristic and would only want to include peripheral neuropathic pain because that was known as a matter of common general knowledge to involve central sensitization. In any event, there's no evidence as to quite how rare a number of those central pain conditions in Dr. Scadding's table were. And it's important to understand that although, for example, brain tumours may be sadly quite prevalent, it's only it may only be in a very relatively small proportion of those that pain itself has experienced, which is why, of course, they are so dangerous. So you just don't have, I'm afraid, any evidence before you to be able to assess the propensity of the various conditions in Dr. Scadding's table, other than the findings of the Court of Appeal at paragraph 59 that peripheral neuropathic pain was much more prevalent. And we do submit that the absence of stroke and multiple sclerosis in the specification of the patent, being the most well-known central neuropathic pains, would be entirely consistent with the skilled person, considering that it was restricted to peripheral neuropathic pain. So everything points one way to the genus of types being all peripheral. So, my lords, we say that plausibility is something the skilled person equipped with the common general knowledge can either see from the patent or not. It's inherent. It was very clear to Dr. Scadding immediately. The suggestion that we had to have a trial to find this out is rather trite, given his evidence, and it's equivalent to having to say, oh, well, if you've taken a day to argue summary judgment, it can't be a summary case. It's just not applicable to an assessment of the technical disclosure of the patent. There were so many other issues at trial that took the time up, and this, in fact, very little time was spent on this particular issue. So, my lords, in conclusion, on the basis of the findings below, if central neuropathic pain was implausible, it will be immediately apparent to the skilled person on reading the patent that if the claim covered central neuropathic pain, it would be invalid. My learned friend took you to the judge's reasoning. He had 4 reasons, paragraphs 258 to 261. None of those were adopted by the Court of Appeal. The first point, that there was no reference to peripheral in the patent, is just circular, because that begs the question. The second point, the reference to the ISP definition, doesn't assist because it wasn't the common general knowledge and there was mixed use of the definitions. The third point, that it is descriptive and not definitional, in fact, the Court of Appeal disagreed with, and they said that the sentence in paragraph 6 was a pointer. And finally, the findings on phantom limb and fibromyalgia were overturned on the facts by the Court of Appeal. So none of those reasons of the judge applied in the Court of Appeal. The only reasons the Court of Appeal gave were the breadth of the other claims and the fact that there was no usage it held to exclude central pain. That's paragraph 114. But it was wrong about that, as I showed you earlier. It had already held at paragraphs 110 and to 111 that there was varying usage, and so it shouldn't have drawn the conclusion it did in 114. And for the reasons I've given, the breadth of the other claims cannot assist. If anything, they support a narrower claim 3. The court ignored the definitional nature, ignored the aestem generis rule, ignored the principle of a validating construction, both in the patent sense and more generally, even though the findings were that there was uncertainty, and they were inconsistent to apply plausibility as a low threshold test, but then refused to take it into account on construction. So they should have construed in accordance with all the accepted principles and consistently with the admissible evidence. So, my lords, for all those reasons, we say our appeal on construction should succeed.
That makes one point, and I really hesitate to say anything, but it's crucial because my friend, I'm sure, will agree that if one looks both at paragraph 259 of Mr. Justice Arnold's judgment and the Court of Appeal's judgment, there is a finding that the definition of neuropathic pain is the IASP definition, based upon my learned friend's own experts. Therefore, it's common general knowledge based on the IASP definition. Therefore, my friend, I'm sure he's not doing this deliberately, my friend is quite wrong to say that neither the judge nor indeed the Court of Appeal accepted the IASP definition. So in simple terms, you will have this. The IASP definition splits neuropathic pain into two parts, central and peripheral. That finding was not disturbed in the Court of Appeal.
What's the Court of Appeal reference?
I'm just going to... So that was just on
This is going to have to come out of your time, your side's time.
I'm not going to take any more time over it because the court will no doubt read both Court of Appeal's judgment and Mr. Justice Arnold's judgment. But you have my point that the definition of neuropathic pain is the IASP definition. And it's just far too late on the last day of a Supreme Court of Appeal for my friend to be giving some evidence that that's not the definition.
Well, I don't accept my learned friend's characterisation of that paragraph of the judgment. It's not in dispute that the IASP definition was well known in the sense that it was part of the common general knowledge. The issue is, was it the only definition and the only accepted definition? And
it's
the judge,
a definition.
It's a definition.
Which the Court of Appeal the judge took account of.
The judge took account of.
Other points as a pointer.
Yes, but the Court of Appeal didn't, crucially. So there's no finding in two...
Where is the Court of Appeal reasoning on this?
Well, firstly, in paragraph 10(3),
Yes.
I got it. Thanks.
I'm told MS 550,
Yeah.
Yep.
paragraph 10.
What?
That doesn't carry it terribly far.
Perhaps I can help.
I think let's just take one at a time.
So just on,
Unless you're going to give the reference.
I'm going to give a reference,
Yes,
only
that-
just to speed things up, but
Yes.
Your Justice was paragraph 66, MS 562, sets out the judge found.
That's very helpful.
And then, but he doesn't go on because there is no challenge to that finding in Mr. Mitchelson's appeal. So
Yes.
paragraph 66. Paragraph 66 to 67.
Yes. Right. Well, I think I don't know what you're proposing to do about Lord Panic, but I think there's probably
Yes.
one minute for him to say everything he has to say.
I do apologise. Can I just finish this point? There was no finding by the judge that the ISP definition was the only definition. Paragraph 10(3) of the Court of Appeal explained one definition of neuropathic pain is pain initiated or caused by a primary lesion or dysfunction of the nervous system. And then in paragraphs...
What you're saying is the question is whether it's used in that sense.
Yes, and there was no finding that there was only one definition that was, in fact, contrary to that, paragraphs 110 and 111 of the Court of Appeal expressly record that there were varying definitions, and indeed, Professor Wolf's evidence that it was rightly or wrongly commonly used at the priority date to mean peripheral neuropathic pain.
Yes. Right.
Unless I can assist you further.
Can I come over there?
Yes, of course.
Can I ask your Lordship's indulgence, 5 minutes?
Well,
I'm in your Lordship's hands. I mean, we have used up our time. But,
we'd better do that. Yes.
I apologise, my Lords. Claim construction, validating principle. We submit that my friend Mr. Saini has provided no basis for distinguishing patent law from contracts, deeds, statutory material. On the other hand, he gave various reasons. None of them provide any basis for a distinction. Reasonable certainty is needed in those other areas. In those other areas, there may need to be a trial on validity, maybe problems about whether the contract is valid or a settlement is valid. he said, well, there's here we have a grant of a monopoly which affects third parties. That is equally true of public law instruments, of statutes, statutory instruments. And fourthly, he said, one can explain the 19th century cases on the basis that there was no power to amend the patent in those days, but that may also be the case in relation to contracts, trusts, statutes. Those can all be varied, but nevertheless the validating principle applies. Abuse of process, my friend says, well, Article 1383 simply obliges the state to provide a means by which claims can be amended. We do that by Section 75, but Section 75.5 requires the relevant principles under the EPC to be looked at, and we showed the court the guidelines, and the guidelines provide a basis for principles. In any event, we say it's disproportionate for the reasons that your lordships have heard to prevent us from amending. On infringement, 2 points. My friend Mr. Speck drew to your lordship's attention the claim. He says that the claim must be defined, the infringement must be defined by reference to the claim. And he says it's the intention of the manufacturer which is decisive. In fact, the Court of Appeal's approach in both the interlocutory judgment and the final judgment was to define the claim by reference to the purpose intended by the user of the product. Can I just give your lordships the references? In the interlocutory judgment, Core Volume 3, MS 708 to 709, it's paragraphs 120 to 121 and 126 to 127. And in the substantive judgment, Lord Justice Floyd, paragraph 212, which is MS 594, referred to those earlier paragraphs with approval. The other point I wanted to make is that my friend Mr. Speck's approach, that we should look at subjective intention, provides very little assistance to the pharmacist about whose interests Mr. Speck expressed such concern. On my friend's approach, if the manufacturer has a malign intention, all of the product infringes and there will be liability. He accepts that, even though the supplier, the pharmacist, may have had no way of knowing about malign intention of the manufacturer. An objective approach, focused on whether reasonable steps have been taken, would provide much greater certainty for those concerned. And if one looks at matters such as the packaging, whether the manufacturer has produced a quantity which substantially exceeds the volume of non-patented use, and any other communications by the manufacturer with the pharmacist, that would provide an approach far more helpful to those further down the line. I'm not abandoning our foreseeability test, but I can recognise, even in 3 minutes, a lack of judicial enthusiasm for the submissions made in opening. My Lords, I appreciate the indulgence.
No,
there
on
are
the
other
contrary,
points. I will happily seek to answer them.
Yes.
That's all I have time.
Sorry, you said on the objective approach.
Yes, my Lord.
On the objective approach, you're still looking at the user's intention.
No, as I understand it, your lordships were putting to all the parties that there should be an objective approach looking at what
The manufacturer.
or further down the line, the supplier has done, if the supplier is in the firing line. And I'm saying to your lordships that if we're really concerned about the interests of pharmacists, an objective test that looks at what the manufacturer or the supplier has done is far more helpful to the pharmacist, because the pharmacist can then form a view, which is what Mr. Speck says he's concerned about. He or she can form a view as to whether or not this product, which is the result of the process, infringes or it doesn't. A purely subjective test provides very little guidance for the pharmacist. That's the point I'm seeking to make.
It sounds as though you would be content with the approach adopted by the German court in the estrogen case, that you're asking yourself whether the manufacturer has manufactured this product for use for, in this case, treatment of pain. And you can answer that question positively if it appears either from the packaging that that's the intended use, or alternatively from the surrounding circumstances, as, for example, the volume of material that's been manufactured.
You have to look at all the circumstances. We would prefer the foreseeability test. If that's not the right test, then we say the reasonable steps test, which the Court of Appeal adopted, paragraph 217 of the final judgment, is the appropriate approach. We say the intentional, the test of subjective intention is unhelpful and it's unprincipled because subjective intention forms no part of patent law under Section 60. That's how we put it, Lord.
Thank you very much. Yes, Mr. Speck.
My Lords, in opening, I'd understood my learned friend Mr. Mitchison to concede that plausibility was part of the law of insufficiency by basically dropping what I think he called the trips point and saying, I'm not going to run that there's no part of it at all in the law. In reply, if I wrote it down correctly, my learned friend said plausibility does not add anything to the enablement test, which the court, unlike the EPO, is in a position to carry out. So in substance, what my friend is saying is he wants to go back on the concession that he gave in opening, and he wants to say that it adds nothing and is not really a test once one gets into litigation at all. So my first point is it's contrary to the way he put his case in opening. Secondly, as I understand it, because he went on to deal with the point, he also persists in saying he has a right to put in post-published evidence on plausibility. I really don't understand why he's worried about that at all, given that, as I've understood the case that he put to my lords in reply, it doesn't matter. Why does he want to put in post-published evidence on plausibility if the only question that actually matters is enablement? Just on that, it's a subsidiary point because of the way my friend put his point, but he didn't have an answer to the way I explained it did become relevant when it was a challenge to plausibility in the kind of circumstances where it matters. All he did is to say that's what he's trying to do here. But in fact, it's not, because what I was explaining was a situation where you're not trying to fulfill or to fill a deficiency in the patent, but you're trying to address a separate question as to whether or not, in fact, what was plausible turns out not to be true. So he's not trying to do that kind of thing. My Lords, the second area from my friend's submissions this morning relate to hyperalgesia and allodynia. And in my submission, you heard a quite extraordinary submission. He now says that he has two separate unifying theories, and as I've understood it, he has the two to span separately from inflammatory pain to peripheral neuropathic pain via central sensitization that way, and from inflammatory pain to central pain because of hyperalgesia and allodynia.
Weren't there findings about this in the court below, about what the limits that could be used about allodynia and hyperalgesia?
Indeed, but it's not just that, it's the fact that the case that's now being advanced
has never been heard of.
It's never been heard of before.
Yes.
The first point I'd make is it actually rather highlights what I thought I'd made clear was my answer to the CML case, which he said I didn't have, and that's because in this case there's no unifying characteristic, and he's highlighting that by saying I have to find another one. Here's a second one. But the very fact that my friend is seeking to make this point in a reply speech in the Supreme Court to raise, as it were, a second unifying theory just goes to show the paucity of the position that he's in. My Lords, the next point is my friend took you to some extracts from Biogen and read you through some part of it which he liked to characterise as something to do with depth of claim rather than breadth of claim. And, my Lords, in my submission he's doing no more than he did when he took you to Mentor and Hollister. And by that I mean, let me take the court to a section that's dealing with a different type of adequacy or not of disclosure, read the test and say, look, I'm all right. He's just not meeting the point. And it's exactly the same when he read you through extracts of other cases by virtue or by reference to the Sandvik case. My lords, he's just missing the point. The real difference between us was laid bare by a question that my Lord Sumption put to him, when my friend says he's okay so long as the suggestion would not be thought of as being implausible. And he has to put it that way because he knows he's in desperate trouble when it comes to looking at the actual findings of the judge. But that, my lord, is a submission that one can have a monopoly extending to an area where the patent does not disclose a technical contribution. So it's flat contrary to a fundamental principle of patent law, and moreover, it is particularly notable because it's something that I thought I'd been clear in throwing down the gauntlet on, in drawing attention to the fact that he hadn't addressed it at all in the submissions to my lords, and I'm afraid your lordships are left in the dark even after his reply case. You haven't heard a whisper about how his submissions are consistent with that fundamental principle of patent law. My lords, this afternoon's points, the attack on the findings of the judge is the way he characterised my cross-appeal, and he took you to some facts in the Statement of Facts and Issues and some, I think, an additional finding in the judgment. In my submission, nothing I have said to my lords is in any way contrary to those findings, and he didn't, it's notable, try to explain why it was. The next point he made, he positively said, worth trying is good enough. I think he said it in answer to a question from my Lord Sumption. I'll just remind my lords of, you needn't turn it up, but there's a quote from, I think it's Lord Hoffman in Connor, paragraph 112 of our case, so it's MS page 293, making it absolutely clear that that is not good enough to secure a patent worth trying. The next point that I should answer is the suggestion. Has my lord found it?
Yeah.
Yes.
I don't think you need to.
Yeah.
But it's a very short passage that makes it absolutely clear that worth trying is not good enough. Yep. The next issue is the thorny issue of the assertion that the tests show an effect on central sensitisation. This is his paragraph 33 of his reply that I identified as being such an important assertion in my submissions. And several times my friend asserted that the data generally, I think, or specifically a rat-paw formalin test showed central sensitisation is reduced. But he had nothing at all to back that up, and I've explained why the findings of the judge do nothing of the sort, and I've been through the extract in Lord Justice Floyd's judgment of Dr. Scadding's evidence. Mr. Copeland was given the invidious task of finding it, and we heard nothing more.
Can I ask you, that there is a finding by the judge that the rat formalin test wasn't, the results of the rat formalin test were not predictive of efficacy for neuropathic pain.
Exactly.
Is that the same point?
It's part of the point in that if you were to think of a test which is in a direct indication of efficacy, it would not meet it. So if you understand the way I put the point in looking at Salk, you can do it directly, or Salk actually gives you an example of an indirect way, and you get to...
Well, the direct way is that the test is predictive of the relevant characteristic. The indirect way is to say, well, it isn't, but it's sufficiently plausible on the basis of a shared characteristic with something that does have that effect.
Well, the way in Salk and the way my friend has put it is that actually you do it indirectly by showing it has an effect on a mechanism which is involved in the disease.
Yeah. He says, but I've yet to see where it comes from the materials, that the phase 2 of the rat test, because pregabalin only bites at phase 2 of the rat test, that shows it works on the central sensitization process. But I don't know, I'm
It's
still
the same fallacy wrapped
hoping-
up. My Lord may remember that I took you through all of those questions and answers in that section of Dr. Scadding's evidence that's set out in Lord Justice Floyd's judgment. And the very last question was that. It's directed to the rat-poor formulin test. And it's just that it had a role. And so it's the same fallacy wrapped up, instead of saying it's got a role in inflammatory pain, it's got a role in this test. But it's exactly the same fallacy that I identified in my one-pager this morning. My Lords, the next point is my friend, I think, was trying to suggest that SALT should be confined to its facts. Just so my Lords know, it is the case that's discussed in the EPO case law book on sufficiency of disclosure for medical use. So it is the guiding case. If you have Authorities Bundle Volume 18, tab 215, and go to MS page 7142, you can see at paragraph 6.2, level of disclosure required for medical use. Just for your Lords, my Lords note, that the case that's peppered in, the first case they mentioned, and then it's peppered through the beginning of the second paragraph, T609 of 02, that is SALT.
Yeah.
The next point that I should answer, although I think my Lords probably have the point, but just to make sure, my friend suggested that you couldn't have a patent unless it was understood how the invention worked, in the sense of how the drug actually had an effect on a disease. That's absolutely not right in my submission. Of course you can have it if you show it, for instance, empirically, testing it on in a clinical trial, like the example given in my friend's case, or perhaps on a model that was known to be indicative of efficacy, even if you don't know why. My submission has never been that you have to understand all the science below an invention, but you do, when it comes to disclosure of efficacy of, for instance, a therapeutic effect, have to show some basis for why you say that that is so. The very last point that my friend made, Mr. Mitchison, that I need to respond to, he suggests that my thought experiment about the multiple patenting would be wrong. He says that it would not be novelty destroying. But my Lords, that's why I was very careful to take my Lords to the peculiarity of Swiss form claims as requiring disclosure of actual attainment of the therapeutic effect. And that's why my friend was absolutely wrong about that, because he's saying that a patent that doesn't disclose it, just makes it plausible, is good enough. But then he's saying it would deprive a patent claim of novelty. It is obviously not so. And you see that that is the issue that's described by Mr. Justice Burse in Hospira and again in Salk. You are allowing a lower standard than you would otherwise require from a claim like that, i.e. you are saying it does not have to disclose it.
Isn't the question of what point it has to disclose it at? I mean, it will, if it works, if somebody implements it, it will be disclosed at that point, at any rate.
No, but it's got to be in the patent application.
That's your case,
exactly,
yes. I mean, I was just looking at Connor, and I see that it's an interesting case, and Lord Hoffman actually says there's no requirement in the EPC or the statute that the specification must demonstrate by experiment that the invention will work, or explain why it will work. So there's he then goes on later to discuss what level of disclosure it must make beyond mere speculation. An idea which is mere speculation is not good enough. And he cites a case, re-Prendergast applications, but a reasonable prediction of the relations is good enough.
Be a little bit careful.
Yes.
I referred to that for the proposition that worth trying isn't good enough, but that wasn't a Swiss form claim. It was a stent coated in Taxol.
Yeah. But what, I mean, the difference is what? That Swiss form claims are otherwise particularly vulnerable to abusive claiming, and therefore we should apply a more rigorous standard.
More fundamental.
You've got to be particularly careful about, I think I'm right, I just want to make sure that I'm not going off on a tangent and getting that wrong.
You are,
No, it was a stent, you're right.
or treating.
That would be consistent with the passage from the EPO guidance you've just given us, that
What was that reference to?
it's MS 7142.
Oh, yes, 7142, yes.
That
Yeah.
in the last paragraph, about 4 lines into it, 5 lines into it, where a therapeutic application was claimed in a Swiss-type form, attaining the claimed therapeutic effect was a functional technical feature of a claim.
And not much else is if it's an existing product. That's the question.
What are the cases referred to there? T60902 and 4...
That's
Salk.
Salk.
That's Salk, and
That's
433 is something else? It doesn't matter, they're quoting Salk.
They're so
Yes.
unmemorable when they put them like that.
They're quoting Salk anyway, yes.
I mean, I thought your objection to an ultra-low threshold test in this context, in the context of Swiss form claim, wasn't just that it left the field open for armchair patentees, but that it didn't make a significant contribution to the art.
Absolutely, because that is the objection. That is the objection. A couple of points that my friend Lord Panic made. I'm not sure that whether or not they're inconsistent, because I think they are. My friend was relying upon the Court of Appeal test, which is, of course, a test that he doesn't like and doesn't support, and drawing attention to the fact that the intention there is the intention of the end user. And at the same time, he made a further submission that subjective intention would be extraordinary because it's not normal. But it is subjective intention, it's just of a different person in the Court of Appeal test. So in my submission, he can't have his cake and eat it. The last point that I would make is that it's inherent in this, certainly in the written case, in the way that they put the case, that they've accepted that we have taken all reasonable steps in this case. And so where my friend suggests that might be an alternative basis upon which my lords may decide infringement, certainly in terms of perhaps looking at the label as the approach, that he can't maintain a case that there's been infringement in this case, if that's the test in my submission. My lords will recall that he had a 2-tier system set out in his statement of case, and the gateway to get through to the top tier, which he did not contend that we did, was taking all reasonable steps. So I've understood that not to be suggested that we don't meet that test. My lords, I've got to the end of my note with time to spare. And unless you have any further questions, actually I'd better turn round in case people behind me want me to say anything more. Oh, yes. Apparently, Rule 47.1 requires me to say something to my lords now about addressing you on costs.
I don't think it certainly does not. It's probably ought to be changed.
Okay.
But changing the rules
Well,
is...
if I have to say anything, can you take it that I've said it?
We invite submissions on costs when we after we've handed down judgment. And thank you for mentioning it. But
do you have any questions for me?
We ought to change the rule. No. Thank you very much indeed.
Lord, can I just point out that at paragraph 217, Court of Appeal judgment, which is MS page 595, the approach adopted by the Court of Appeal was that when the right test is identified, then the matter should have been considered by the judge whether actually specialists had taken all reasonable steps in their power to prevent the case from being used to treat patent. That was the approach taken by the Court of Appeal. My friend attributed to us some concession that we're making. We're making no concession whatsoever in relation to reasonable steps.
And my lord, I have the homework. I was going to give the references to the second phase of the RAP
Oh,
form.
yes.
It's paragraph 62, 191, and 206 to 207 of the judgment.
62, 191,
206,
207, that's the judgment.
206, 207, and 20 and 78 in the Court of Appeal.
But no underlying materials.
But no,
No underlying materials.
No. And my learned friend, Mr. Speck, referred to Connor, and just to help with that, the claim in that was a claim for treating or preventing recurrent stenosis. So it's the same form of words.
Which case is
The Connor and Angiotech
so
in the
Connor,
House of
yes,
Lords.
yes.
You can see that. It's claim 12
Yes.
on page 1689, and then the passage we rely on is 36 and 37, where Lord Hoffman said the plausibility test was a threshold test. Once you pass that, the question of obviousness is different.
Thank you.
Well, the court is grateful to counsel on all sides for their clear written submissions and also for their clear oral submissions, and will take time to consider its judgment, which will be handed down in the usual way and will, I suspect, take some time.